Donald Trump's role on January 6th in attempting to overthrow the results of the 2020 election and his interference with the peaceful transfer of power constitutionally disqualifies him from holding public office again. That's the argument being made this week in Colorado, where a group of voters, 4 Republican and 2 unaffiliated, filed a lawsuit to keep the twice impeached, quadruple indicted, disgraced one-term ex-president's name off of the state's ballot. Section 3 of the 14th Amendment states that no person shall hold any office if they, quote, engaged in insurrection or rebellion after having taken an oath to support the Constitution. And while Colorado may be the first state to test Trump's constitutional eligibility, it certainly won't be the last. Colorado's Secretary of State Jena Griswold said she's been talking to other secretaries of state about it, telling Politico that, quote, we can expect a lot of lawsuits filed on this issue across the nation. Joining me now is Donald Sherman, Executive Vice President and Chief Counsel of Citizens for Responsibility and Ethics in Washington, also known as CREW, which filed the lawsuit in Colorado on behalf of the plaintiffs. Donald, it's nice to have you here to kind of break this down a little bit more for our viewers. So I just cited to the language of the 14th Amendment, Section 3. It's explicitly clear. If you strictly construe that language, Trump and others are barred from holding public office again. Has this theory been tested before in courts?
Thanks so much for having me on. It has been tested in courts. In fact, my organization last year represented 3 New Mexico residents who successfully utilized Section 3 of the 14th Amendment to remove Couy Griffin, a New Mexico official, from office based on his role in engaging in the January 6th insurrection. The court found a number of things, including that the first time in 150 years that a person who engages in insurrection after taking an oath to defend the Constitution is barred from office. Mr. Griffin recruited people to come to D.C. to go to battle for President Trump to stop the steal. The court also found that you don't need to be convicted of a crime to be disqualified under Section 3, nor do you have to be violent yourself to be disqualified under Section 3 of the 14th Amendment. And there are a lot of parallels between Donald Trump and Couy Griffin. And we believe that there is a very strong case, and this has been confirmed by legal experts across the ideological spectrum, that Donald Trump is also disqualified from this.
Yeah, so Donald, seeing you had success in New Mexico, you got this litigation in Colorado that's currently pending. We know Donald Trump is trying to remove it to federal court. I mean, as lawyers, I'm sure we never thought we would actually be dealing with removal as much as we've been dealing with removal lately. But is this litigation strategy, Section 3 of the 14th Amendment, is it truly a one-size-fits-all strategy blueprint for any and all states that want to deploy it?
No, it's certainly. The Constitution obviously applies to every state and applies across the country, but not every state has the state law mechanisms to afford voters like our clients in Colorado to get into court to sue to remove a constitutionally disqualified official from the ballot. That's one of the reasons, in addition to the fact that we had 6 brave plaintiffs who were willing to put their names forward. Under Colorado law, they have the right to sue to enforce former President Trump's disqualification under state law.
And let's just say that your Colorado case survives a motion to dismiss by Trump, putting aside the removal to federal court, remand back to state court. What will it take to win? Meaning, would you need to prove Trump's conduct and actions leading up to January 6th and thereafter?
Yes, we are prepared to present evidence and witnesses, fact witnesses and other witnesses, to prove Donald Trump was disqualified because he engaged in insurrection against the Constitution of the United States after taking an oath to support and defend the Constitution of the United States. But, you know, it's also important to remember that there's lots of public evidence of this already. There are bipartisan votes in the House and the Senate finding that Donald Trump incited an insurrection. There was a bipartisan report from the January 6th committee that found that Donald Trump was the central cause of the insurrection and recommended that Section 3 be used to ensure that insurrectionists don't once again get the keys to the government. So we are prepared to go to court to prove our case, but there's also been a public case already proven, and we plan to present that evidence and other evidence as well.
So, Donald, there's an op-ed that just came out a couple of days ago. I just had to check my watch. September 7th from Michael Mukasey. I think you know who he is. Former Attorney General, federal prosecutor, and a known Republican, member of the Federalist Society. That's interesting, right? Because two of the leading scholars that are kind of pushing this concept of Section 3, 14th Amendment are actually Republicans, as well as some of the plaintiffs are Republicans. So just the party affiliation in and of itself is not a disqualifier. But Michael says the following. He claims that, and this is far-fetched in my opinion, but I wanted to ask you this. Donald Trump was not an officer of the United States when he took his oath on January 20th, 2016. So because he wasn't an officer of the United States, because he was an elected official, he cannot be barred by the 14th Amendment from seeking re-election. What's your retort, counselor?
He's wrong. There's a lot of people with opinions about Section 3. But there's actually not a lot of experts in Section 3. I think Professor Lawrence Tribe mentioned this in an interview earlier this week. But there is not a lot of debate among the scholars that have studied Section 3 of the 14th Amendment for any length of time. As you mentioned, there was a 126-page article released last month by two conservative legal scholars who studied this issue for a year and concluded that Donald Trump is disqualified, that President of the United States is in office under the United States, in direct contradiction of what Judge Mukasey, former Attorney General Mukasey, concluded.
Yeah, Donald, I got to let you go because I ran out of time, which makes me sad because I really want to dive a little bit more into this. But I am going to note that those two law professors, they're both members of the Federalist Society. And so to your point, again, it's not party affiliation. It's the law and how the law is construed. And in my opinion, it looks pretty black letter. So Donald Sherman, keep us posted on how this litigation is going, not only in Colorado, but in the other states. Appreciate you.